Welcome to this edition of Stevens and Stevens Family Law CLE, brought to you by Center for Child Counseling. And here's your host, Eddie Stevens.
Thank you, Arthur, for that wonderful introduction, and welcome to our Q4 S&S CLE program, where we're going to discuss over 50 family law cases that have come out between June and August of 2023. My co-host, as always, Karen A.
Karen A.
How you doing, Ms. Stevens?
I'll just go with Stevens. That works for me. But yeah, Stevens. So here we are. So 53 cases was a daunting task, but
it was daunting.
We are here for you guys.
But we did it.
Yeah.
And what's even more exciting is, as you may have noticed, I have a Funko collection behind me. And if you've been watching over the years, every episode, that collection gets a little bigger. Well, this year, Funko has teamed up with S&S Law, CLE, whatever it is that we're doing, and they manufactured 2 new Funkos for the 2024 production year. And I have a little surprise of one of them. Karen, I think you have the other one, but here is one of the new Funkos going into production. It is the Eddie Stevens superhero.
Oh my God, that is uncanny. Glasses,
beard, very nice looking suit. And Karen, I think you got one too.
Only equally matched by the beauty and intelligence of the Karen Stevens Funko. There you go.
It looks smart.
Yes, love it. So we are fabulous and famous and funkified now.
Funkified. So thank you to the wonderful people at Funko for acknowledging us and sending us a couple Funkos. That was fun.
I feel like she could just do the CLE now. No? Okay.
She's well dressed.
She is well dressed. Obviously.
They spelled your name wrong though.
Oh my God, let's do this, because our subscribers haven't heard enough of this already. Come on.
Well, it's just by coincidence that we would have this awesome thing that is known as our names. All right, you ready to get dirty and talk about some of these cases, starting with agreements? I'll start. How about that? So, ladies and gentlemen, starting off the June 23, August 23 case law summary is agreements. And the first case is the Robertson-Hochstatter case, blah, blah, blah. And that dealt with interpreting a paragraph regarding interest. And it was really cool because the agreement says the wife shall receive a lump sum equitable distribution payment in the amount of $300,000 on January 1st, 2017. Said payment shall not bear or accrue interest. So the court, January 1st, 2017 came and went, and the court enforced the $300,000 payment and added interest from the date it was due, January 1st, 2017 going forward, because the provision in the party settlement agreement was just no interest until it's due. So the court was the circuit court properly got that one right and read it that they were not going to apply interest until it was actually due. Then the court has the ability to add interest. Long-winded declaration for an easy explanation. Case number 2. Duchitow. You could get in trouble with that.
Right? Oh, stop.
So there's a non-final order, right? That as a matter of law held that something as a matter of law, and for this order to be reviewable as an interim non-final order, it's got to expressly determine as a matter of law that the settlement agreement was not enforceable. So as a matter of law actually has to be in magic words in the order for the non-final order to be appealable. That is what we learned in the Duchitow opinion out of the 5th. Duchitow.
Off the Duchitow, or however you want to say it, Duchitow case. We now have equally hard to pronounce Huete versus Huete Sierra, which is the first case in alimony, the only case in alimony in this last little quarter here. This is a fourth DCA case out of here where we are in Palm Beach County. And this involved a situation where the judge's order was facially inconsistent throughout. There was no transcript available for the appellate court to review. However, the order itself was so problematic. There were a paragraph that said appellant had to pay retroactive alimony, and then several paragraphs later it said, oh, there's no retroactive alimony. So this was remanded on its face of the order for the lower court to correct the inconsistencies. But the problems involved retroactive child support, how much the appellant was supposed to pay in retroactive child support, and whether the appellant was having to pay retroactive alimony at all, like I just mentioned a few moments ago. So this is one of those cases where you hold your breath and say, oh my God, there's no transcript. But lucky for this, Mr. Huete, the order was so problematic on its face, he got by with a really good, well done appeal. So that is the only alimony case, and it was kind of more about procedural than alimony.
Yeah, we got a lot of cases this quarter about being able to reverse without a transcript. Fun stuff. Next case, it goes into appellate world, and this is the Carter Meadow case. And this is an interesting case where it dealt with a petition for cert to quash a trial court's order on discovery. And then the case settled, and no one told the appellate court, and the appellate court got kind of upset. You can tell by reading the opinion. And the appellate court kind of blasted the attorneys on record. They filed a motion an order to show cause why the petition should not be dismissed as moot, and why sanctions should not be imposed for failure to notify the court promptly the underlying matter had been concluded. And the court writes a very poignant opinion going into where they have the authority. The court must rely on counsel to present issues fully and fairly, and counsel have a continuing duty to inform the court of any development which may conceivably affect an outcome. That was violated in the rules regulating Florida Bar 4-3.3. During the pendency of an appeal, the duty of candor imposes an obligation on counsel to notify the court of any development that may conceivably affect the outcome of the litigation, including facts that may raise a question of mootness. So you do have a duty as an appellate attorney to be candid and advise the court when an issue may have become moot. So be mindful of your mootness. I think that's a cool t-shirt, mindful of mootness.
I like that. That's cute.
We're going to do some bumper stickers after that. A new Funko.
A new Funko.
The judicial Funko. All right. Appeal case number 5, Boggs v. DOR. Christopher Boggs appeals an award of child support entered after a hearing before the Division of Administrative Hearings, DOA. And the husband or dad alleged that he was unable to afford the child support, and there was no transcript. So this is an instance where there was no error on the face of the order. It contained findings of fact, everybody's income, and you can't really appeal that without a transcript unless you show the error on the face. So Mr. Boggs, you struck out there. It takes us to attorney's fees.
So we have quite a few attorneys cases this period of time from June to August. The first one is number 6 in your material, which is Nassef versus Eddie or Edie. This was a paternity case out of the 4th district.
That's pronounced Steffens.
It's That was a terrible dad joke. That was like a terrible dad joke.
That's why I'm here.
Perfect. Okay. So Mr. Nassef and his paternity case, there were fees awarded in the case, but the problem with the fees that were awarded here was that the court didn't make, the court made findings as to the number of hours that were expended in the fee award, but the court didn't take it that next step in the order and determine if the fees were reasonable or not, that magical R word when you're dealing with fees. So they made a finding of the amount, the number, but not whether they were reasonable. And because of that, the fee part of this order was reversed and remanded. As an aside to all of this, even though we're talking about attorney's fees, in this case, there was also the dad was also found in contempt, but that was also reversed and remanded because the contempt was not noticed to be heard. It wasn't properly in front of the court, and the court just took it this step too far and said, oh, we're going to hold dad in contempt. So the contempt part of the order was also actually stricken from the final judgment. And on the reversal and remand part of it, it was about the fees for the court to make that reasonable finding. So that's the Nassef case.
These attorneys always find something to whine about.
This
Due
is important,
process.
but it's important not due process. The
Sure.
fee part's important when you're writing these proposed final judgments. Like I just wrote one today. You've got to remember that you're making findings. You have to then take it the next step and see that there was a reasonable, the fees were reasonable. So because you've got this case now and a million others that say you got to have it.
That's what we call a required finding.
Mm-hmm.
Golding is next, another fee case that dealt with findings of fact in an appeal. Generally, the absence of transcript precludes appellants from establishing reversible error on appeal. But an award of attorney's fees without adequate findings justifying the amount of the award is reversible on appeal, even when you have an inadequate record. Failure to include in appellate record transcript of hearing on former husband's claim for attorney's fees in divorce proceeding for former wife's contempt and for fees incurred did not preclude wife's appeal of attorney's fee order, where several orders appear on the face. This is just like the Eddie case.
I call these like the really lucky cases. You know, when you don't have a transcript like that, these people are so lucky that it's enough on the face of the order.
Footnote 5 is an important one. Errors appearing for the first time on the face of a final order are preserved if raised in a motion for rehearing. So that's the if you don't have a finding of fact, you have to have a motion for rehearing. And in this case, the wife had a motion for rehearing. There's also some things lacking, like ability to pay, in addition to all that other fun stuff. So if you're doing fees, you got to have the required findings, even without a transcript, as we've learned.
So next two cases and fees were on number 8. This is the Ernfredson versus Ward case out of the 5th district. This was a dissolution of marriage case. And in this case, the court made some findings and I guess was trying to do the right thing, but really failed at doing so. And what the court said is, hey, this is a short-term marriage. The wife had requested fees in her case. But they said, because it's a short-term marriage and, you know, we're not going to award fees to anybody. But the problem was here that the court has to go through the requisite findings and analysis. The court has to consider the financial circumstances of both parties and then make sufficient findings of fact on why they are awarding or not awarding attorney's fees. Simply saying like, hey, this is a short key or a short marriage is just simply not enough. So when the court denied the wife's request for fees with no other findings, that part of the final judgment of dissolution was remanded back for the court to make the appropriate findings. It may still come to the same conclusion, but you do need to follow what is required. And that was not contained in the Ernfredson order. The last and final case and fees this quarter is the Gable versus Gable case. This is a 1st district, again, a dissolution of marriage case. And this is kind of piggybacking off the other one where the court didn't make finding as to whether the fees were reasonable. Here, this court didn't make findings as to what the hourly rate, the hours expended, and the appropriateness of the fees and any reductions the court was making. So they didn't even get to the reasonable here. In this one, the court just didn't make any findings as to numbers for the basic start. So this was also problematic. The other thing that was problematic for the Gables and this appeal was that the record was devoid of any evidence of actual presentation by the attorneys as to what the hours were, what the amount was, and what was done in this case. So it was just problematic all around. But this is the Gable case. Again, you're drafting those judgments, those proposed orders, or presenting your case, you've got to remember what has to be proven. So reasonableness, amount, hours, anything you're asking the court to reduce, all of that needs to be in.
And that will take us to equitable distribution land. And the first case there, case 10, Prince v. Honore, that is one of my appeals. I got to represent the former husband. And basically, the court erred by saying, I'm going to use the date of filing for all values, and then valued one of the properties 3 years after the date of filing without explanation. Now, the appeal presented many more issues than just that, but that seemed like a no-brainer. So as an appellate tip, if you know you're going to lose an issue and they're going to write an opinion, it's really good to concede on that issue so they don't write a full opinion on all the issues. So I would suggest if I had not conceded error, they might have looked at other issues, which at the time seemed like they were viable issues. But conceding the obvious issue, all of the other issues just went away. So a thought when you have a multi-issue appeal and one of them seems like a no-brainer, I would go ahead and concede. That takes us to case number 11, the Rivera case, which dealt with non-marital property being sold. And then the proceeds of that were deemed marital. And the appellate court broke it down and said under Florida's ED statute, marital assets include assets acquired during the marriage individually by either spouse or jointly by them. Non-marital assets, which are not subject to equitable distribution, include assets acquired by either party prior to the marriage or in exchange for such assets, or by non-interspousal gift, bequest, devise, or descent. Here it was inherited and the husband sold it during the pendency. Then he bought something with the proceeds, and what he bought was deemed marital. And there was no evidence of commingling the proceeds once he sold it. So that marital item was reversed and remanded. Case number 12, Crocker v. Crocker, dealt with the distribution of a party's disability policy. And when you have retirement, that's subject to equitable distribution. If you have disability, that is not subject to equitable distribution, but it is an asset from which a party can have income and you can base alimony on it. But you can't use it for both. So Florida law is pretty resolved that disability benefits are considered income, considered for alimony purposes, and are not considered for equitable distribution. So that is the Crocker case, and that takes us to Naranjo.
Naranjo versus Ochoa. This is a 4th district case from here in Palm Beach County where we are. This was a dissolution of marriage case. This is actually a very lengthy, interesting opinion if you're nerdy and like to read about marital appreciation and non-marital appreciation on things. But the root of all of this very long case is that the wife had received a advance on her inheritance from her mother, or I think it was her parents. And when she got that money, it went through the party's joint bank account, but it literally moved through there and then went out to an investment. And the wife had chosen like 3 investment accounts to invest the advanced inheritance into. So there were 3 accounts. She parked the money, she invested it, and never did anything else with it throughout the duration of the marriage. And the husband at the time of trial argued that the appreciation on that money was marital, and that it should be subject to equitable distribution. The husband also argued at the time of trial that pursuant to 61075, the wife's efforts in the investing of that money was also marital efforts, which again then colored the appreciation on this money to be marital. And in fact, the 4th district in its opinion actually quoted the closing arguments of these 2 attorneys, and they were so divergently different, as we see so much even in our own practice. But the husband's attorney kept harping on the fact that it didn't matter whether the money had moved through the account or not, because the wife had taken action during the marriage and that the investments had increased. It was 100% marital, and it was not hard to see that. But the 4th district actually said that because the wife invested it and parked it and never did anything further with it, that was not marital effort. And the fact that it had washed through the account for a minute before it went into the investment accounts was also not coloring that account or that money to be marital. So the fourth district said, and again, there was a long discussion about enhancement of non-marital assets. This was not the classic case of an enhanced non-marital asset. And that the fourth district said the trial court actually erred in distributing that appreciation on the wife's money as some sort of a marital asset when it was not. So very interesting read, but clearly pushing a button and investing one time in an account is not marital effort, despite what the husband's attorney and the husband might have argued at the time of trial. So that is
that's a close call.
Close call is a long analysis, but very interesting case.
I think if you're going to reverse something like that, you have to really show that the original play was miscalled. I don't know. I don't know if I agree with that one, but God bless the fourth. So our next case, Gayer v. Nasita. Lots of little things wrong. Judgment was reversed, like tax credit was given to a party that wasn't supported. The court didn't distribute one of the SBA loans incurred during the intact marriage. Court failed to distribute a credit card liability, and there were some inconsistencies between the final judgment and the attached ED chart. So judgment affirmed in part, reversed in part. Case 15.
All right, so case 15 is Pukin versus Pukin, and this is a I knew you'd enjoy that. Not Putin, but Pukin. This is the 6th district court case. That's still
Putin's less effective cousin. I'm kidding.
Oh my God, we are just chock full of dad jokes today. All right. This is also number 27 in your material. So we're going to talk about this again in a parenting issue, but for the purposes of equitable distribution, what the problem with this was is that the equitable distribution that the court ordered had left out a liability of the parties. And that was an $11,500 promissory note that the husband had to his parents. It was borrowed during the marriage. It was used for marital expenses, but the court left that off its distribution schedule and failed to identify it, value it, and distribute it. So if the court does not value and distribute all marital assets and liabilities in its plan of equitable distribution in a final judgment, then it must be reversed if you leave something out and all of that. So
I thought this was really interesting because it wasn't represented by a promissory note.
Correct. But there was a loan.
So you have some, I mean, you could use the case for that because the opinion specifically says there was no promissory note, and it looks like the wife got in trouble for giving a snarky remark because the appellate court specifically highlighted on that was the only thing in the record to contradict it.
It was very funny. It's actually bolded and indented in the case that the wife said, "Oh, this is kind of convenient," or something like that. He takes loans and we have to now account for it. My parents loaned us money because they care, or something obnoxious like that. So it was not well received, folks, by the fourth or the sixth. Sorry, the sixth.
So for those folks that think you have to have a promissory note in order to establish a liability, maybe not. Maybe not. Our next case is Franksman that dealt with the $2,000 worth of stock that the trial court called non-marital. But the only evidence adduced at the dissolution hearing was that the stock was acquired during the marriage. Therefore, it's presumptively marital. I think we're going to come back to that and address this case again when it comes to name changes, but I'll let Karen handle that. So we're on to our next case, 17, Beauchamp. Beauchamp is an interesting ED case that dealt with the selling of an asset, and then the wife put the proceeds of that asset into an account, and then the court distributed that account. So that was kind of double dipping. So the court found that it should have not charged the wife twice for the same asset. That's the Beauchamp case. Next, we have Douglas, and Douglas dealt with the trial court's error in failing to make findings on the record or in writing as to why it found real properties titled only in the husband's name were marital assets. As required by the ED statute, this is not harmless in a hearing on ED, and there was nothing in the record indicating why the trial court classified 5 of these properties as marital. So that prevents any kind of appellant review. So the issue is remanded back to the trial court to explain why it did that. Simple as that. Simple. Our next case is Winrow v. Hyder. 1 second. And that's case number 19. That dealt with a line of equity, a HELOC, taking out on real property that was classified in the parties' prenuptial agreement as the husband's separate property. So even though the husband used the proceeds of the HELOC for marital purposes, the prenuptial agreement said that was the husband's separate property. So any encumbrances coming on his separate property was the husband's separate property. So the HELOC was taken out of the marital estate and signed to the husband as a non-marital debt. Next case deals with imputation. It's case 20 in your materials, the Allison case. And in the Allison case, the trial court was reversed by putting the burden of imputation on the wrong party. The burden should be on the person asserting underemployment and seeking imputation, not on the recipient spouse. And that takes us to the beginning of our injunction cases, but not the end.
At the beginning, yeah. So number 21 in your materials is K versus Wilson, which is the first DV injunction case. This one involves domestic violence. And there was an injunction in place, and the petitioner sought to extend that injunction about 3 days before it actually expired. And the lower court did extend it, but the second district has reversed that, because at the time that the petitioner sought to extend the injunction, there was no evidence that the petitioner had suffered or was suffering from any substantial emotional distress, nor did she have a reasonable fear of imminent domestic violence. There was no new acts of domestic violence and whatnot during the period that the injunction was in place. This is a tough situation that you see a lot of times with clients when you have an injunction that has a limited time frame, and they say to you, well, of course he hasn't caused more domestic, or she hasn't caused more domestic violence because there's been an injunction. But with the way that the statute is regarding DV injunctions, if you want to extend one that is in place, you must show that there's an additional act of domestic violence that's occurred, or that the petitioner has a reasonable fear of imminent domestic violence. So if you don't have a new act, you've got to prove this reasonable fear of imminency in this domestic violence arena, and that is very hard on many occasions. So that initial,
like getting a new injunction.
Yeah, new injunction. So it is very hard when you're doing these cases and you're representing these clients. You've got to like hit it hard from the beginning and try to get them as long as possible, because extending is oftentimes nearly impossible. So that is the K case. The next injunction case is Piper, which is a 6th district case that also involved a domestic violence injunction. And this case was an initial injunction that was entered, and then the respondent had appealed. And unfortunately, what the respondent was really complaining about is that they wanted the 6th district to basically reassess the credibility of the witnesses who testified at the time of the injunction hearing. And that is not the purpose of the appellate court. And so the appellate court gave a very brief opinion in this, and they are not here to reweigh credibility. They're here to correct errors, fact findings, conclusions of law, not credibility. So trial court is the court that's vested with that, exclusive right. So this case was affirmed, or the injunction was kept in place.
Thanks for breaking
we'll be back on injunctions in a little later. You'll see in a moment.
Modifications, case 23. The trial court denied an alimony modification, but never determined what the starting point was. So the court never figured out what the husband's initial income was when he got divorced, which is kind of a important factual issue to resolve in a modification, because you're showing a substantial change of circumstances. So you have to show the starting point. And if you have a judgment that you're unclear as to what someone's income is, that's a failure as an attorney, because it's our job to set those data points up so we're preserving the ability to do a proper modification later. So either have some child support guidelines or some type of information embedded in the petition that lets us understand what alimony was based upon. Otherwise, you're looking at financial affidavits that may have been filed sometime not with the final hearing, and it's up for court to decide. So practice tip, put in your settlement agreement or your judgment starting point.
All right, so we told you we'd be back to Franksman, and we are. So now we're dealing with Franksman. We talked about the equitable distribution with Eddie a little while ago. This is now the name change portion of it. And in this case, the court denied the restoration of Miss Franksman's maiden name. And the first district said, no, that's improper, because Florida statute 68.07 provides family court with the jurisdiction to restore a person's maiden name in a dissolution of marriage action. The normal restrictions that involve name change and whatnot don't apply when you're dealing with the restoration of a maiden name in a dissolution of marriage case. Yes, we ask those famous questions of, you're not doing this to evade creditors and, run from the law and all those sorts of things, but you don't have to do a formal name change petition if it is just a restoration of name. I've seen clients who have wanted to change their name as a function of the dissolution of marriage case. That is not what the 6807 talks about. It's just talking about restoration. So that is what Franksman teaches us, that the family court has exclusive jurisdiction to do restorations of name.
No fingerprints.
No fingerprints, no background. Yep. Number 20. So we're going to hop over to parenting for a few minutes, and we have some parenting cases. Number 25 is Russell versus Aronowitz. And this is a 3rd district case out of Miami-Dade County, and this involved a modification action. So there was a 2014 final judgment, and then there's a 2017 temporary modification order where the father was given majority time sharing in all decisions over the party's minor children or child, because the mom had failed to meet the minor child's extensive mental health needs. So there, from 17 forward, dad was exercising majority time sharing and making all decisions. And mom had gone in on a modification action. And unfortunately for mom, there was no transcript available to the 3rd district to review. But the 3rd district noted that the court had done a very well-written order, so that the court was able to say that the findings were based on law, and the appellate court is not there to disturb an order that is well written by the lower court, and in the absence of a transcript couldn't analyze that anything was improper. So this case was affirmed. The next parenting case is number 26, Tucker versus Tucker, which is the 2nd district case. Which, let me write that. We had 5th in your materials. I apologize. We'll fix that. 2nd district, obviously, before we publish this. So this was a dissolution of marriage case where the wife was granted sole parental responsibility and dad was given very limited supervised time sharing. The parenting plan in the final judgment also gave dad strict alcohol restrictions. Dad, by the way, was an attorney and had a lengthy history of significant history of alcoholism, alcohol treatment for that disease. There was anger issues by dad. There was some threats of harm. There was domestic violence. There was an extensive history of things in a case that would cause a court to have concern about a minor child's safety. So the court granted mom the sole parental. Mom, by the way, was a physician and was basically the primary caregiver for this child throughout her life. Dad gets this limited time sharing with supervision. What was different about the Tucker case is that there was no steps or like a plan for dad to get away from supervised time sharing and to restore any kind of unsupervised time sharing. And that's kind of a different situation than we've seen in the case law over the years. There was the old keys to the jail cell kind of concept where if court put supervision or restrictions on a parent's time sharing, you had to have identifiable steps on how they were going to get back to or get to a place where the time sharing was not so restricted and not supervised. But Tucker changed all of that. And Tucker said that even without specific plan of action, that the granting of supervised time sharing was fine, and you don't need steps. So now you have the 2nd district saying you don't need steps in a supervised time sharing case. We had the 5th a few months ago in the, I think it was Picanici case, or a couple of years ago, the 5th district had a case like that. So now you have the 5th and the 2nd saying you don't need steps anymore. So the entirety of this final judgment, except for one part, was affirmed. So sole parental was affirmed, supervised time sharing without steps was affirmed. The one thing that was reversed on the issue was that the court kind of overextended its boundaries and put alcohol restrictions on dad about what he had to do and the kinds of treatment he had to get. And that was just overstepping when it wasn't related to time sharing, especially because dad's time was supervised. So it was the second district said it was an abuse of discretion. So that part of the order was reversed, and that is Tucker. The last case we have in parenting, we talked about a few moments ago in equitable distribution. So now on the parenting side of it, this is that Pukin case with the fun name out of the 6th district, Pukin. In this parenting plan, the court ordered that there was shared parental, but failed to take that extra step, which is to put in there now, pursuant to 6113 2B 3A. 6113 2B 3A is that if the court orders shared parenting, you must have an inclusion that says that either parent can provide consent for mental health counseling and treatment for a child. That was not included by the court in the Pukin case, so that issue was reversed for the court to correct its judgment. Very important. I see proposed parenting plans all the time from attorneys in out there in the community who are not including that language and not taking that extra step. So under the shared parenting, there must be that inclusion of that either parent can provide authority and consent for mental health treatment for the child. And that are the parenting cases.
And next we have a fun procedure case. I love when I have squibs that say we're talking about this issue, because that means it's a really long opinion and it's very select. And this quarter's entry is the court's inherent authority. Inherent authority, and what does that mean? And in the Hassan case, former husband was ordered to pay support, child support, additional support, and he was required to pay it through the support depository. He paid not all of it, but some of it, $55,000 directly to the wife. And the court heard that issue, and because he did not pay through the depository, the court decided through its inherent authority that they were not going to award the husband a credit for the dollars he paid because it didn't go through the depository. So that triggered the second DCA to write a multi-page opinion about the court's inherent authority. And it's not that inherent, meaning the court can't just do anything. And the bottom line is an inherent authority remedy must be fashioned by a court to have a rational nexus to the wrong it is seeking to correct. And we get all of this great history about inherent authority. As identified by the United States Supreme Court, the existence of certain inherent powers within our courts have long been recognized as powers which cannot be dispensed with because they are necessary to the exercise of all others. Inherent power governed not by the rule or statute, but by the control necessarily vested in our courts to manage their own affairs is to achieve the orderly and expeditious disposition of cases. Among the recognized inherent powers is the power to punish for contempt. The contempt power extends to conduct before the court and conduct beyond the court's confines. The court has recognized certain limits on these powers. First, the exercise of inherent power must be a reasonable response to the problems and needs confronting the court's fair administration of justice. And second, the exercise of an inherent power cannot be contrary to any express grant or limitation on the court's power contained in rule or statute. Thus, an inherent power must be a reasonable response to a specific problem, and the power cannot contradict any express rule or statute. So in bypassing $55,000 of credit, the appellate court found that did not hold a rational nexus to the wrong it was seeking to correct. So it reversed the Hassan trial court in a very, very lengthy opinion about inherent authority. That takes us to 29.
That was a long one.
Thank you.
So, 29 is King versus Giardina. This is a first district case. Oh, and it falls under the no transcript provided litany of cases. This was an appeal of a temporary injunction, no transcript. So the first district said, hey, we got to presume that the trial court's judgment was right because it's based on the evidence heard at the hearing and we don't have a transcript. So this is one of the ones that does not fall into the lucky category I joked about a few moments ago. This one failed. So you spin that wheel sometimes, but this one was not an error on the face. So they needed a transcript and the entire underlying order was affirmed.
Like the 18th case we've had like that this quarter.
It's 18, the 10,000th this year. It's like, come on, people.
Our next case is Hakeem that dealt with a petition for writ of certiorari regarding a discovery order on a party's medical conditions. And for a writ of certiorari to issue, it's well established that the petitioner must demonstrate that the challenged order, 1, departs from the essential requirements of law, 2, results in material injury, 3, such injury is incapable of correction post-judgment, and 4, because of their private nature, an order improperly compelling the production of medical records can constitute, there's only 3. And then there's the conclusion that it can constitute irreparable harm because we're dealing with private health records. But in this case, Mr. Hakeem had placed his mental and physical condition at issue by referring to his poor health when seeking relief from the trial court. A few examples, and he says he earns nominal income because he is disabled. He has severe and serious health issues. He suffers from heart issues, high blood pressure, prostate issues, and poor health, depression, high blood pressure. So if you're going to put that forth to get relief, then you have to be ready to, have discovery on it. So if you put your own health at issue, you got to expect that the other side's going to go after it. Easy peasy. What's next?
All right, so next is a change in family law rules and forms, and this is listed as 31 in your materials. And this is the change. The court amended Administrative Rule 2.516. This is the email designation rule. And now any pro se litigant is also required to designate a primary email address unless they're excused by the court, like I don't have the internet or it's 1985 or whatever the excuse is. Every pro se litigant now has to file a notice of designation of primary email. They can include secondary and tertiary, but they do need to participate in the same procedures that most of us as attorneys of record have done for years. It's now part of the rule. So that's what 2.516 was amended to with this new family law form. And then we're going to hop over to number 32, which I believe Eddie has probably a personal interest in.
It's proof that the appellate courts know how to spell our last name. It's Stevens with a PH. Got that? Stevens with a
I purposely
PH.
did not cover this case because I disagreed with the naming of the court case.
Just for this moment. So this case dealt with excusable neglect and a attorney missed a trial, but with good reason, because when the matter was set, the attorney emailed the other attorney that he had a conflict that date, but the trial got set for that date anyways. But wait, there's more. Then the attorney caught pneumonia, and then he missed the trial. So all of those things happening is excusable neglect, and the trial court denying that was reversed. Why don't I just take the rest of the cases for this quarter? 33, Chamberlain v. Degner. Trial court abused the discretion granting relief from a judgment when a party was not properly served with the order setting trial, and the court awarded relief beyond what was requested. But the party had actual knowledge of the date of trial, and he chose not to participate. So therefore, due process was not violated. Therefore, he should have been at the trial, and that's not reason for a 12.540 order. Plus, there was a complaint that the court awarded more than what was requested, and the appellate court addressed that and said, well, if you look at the petition that was filed, even though it didn't request sole parental, it had the facts in there to substantiate it. Therefore, it's as if it was a request. So I think the appellate court kind of sidestepped that issue, but that's what you get when you don't participate in your final trial. That's the Chamberlain Degner case. Next is the Gay v. Gay and Mann matter. Trial court erred denying a motion for protection on wife's new finances. Again, a writ of cert. Trial court departed from essential requirements. Petitioner suffered material injury, no adequate remedy. And the appellate court says the new spouse protecting his financial information meets all three of these requirements. So Gay v. Gay and Mann is a good cert case if you ever are representing a party that has to provide private information. Gay v. Gay. Our next case is the Hyatt v. Zimmerman case, and it dealt with a party being ordered to dissolve a trust. Well, the court found that the trial court had jurisdiction to order the former wife to dissolve a trust and compel her to quit claim title of the marital home to the former husband's estate, even though the trial court does not have jurisdiction over the trustee, because the court's in personam jurisdiction was sufficient alone to provide the court with the authority to determine the equitable rights of the parties. So if you have a case involving a trust, that case may be very, very helpful to you. The Hyatt v. Zimmerman, number 35. Next is in re amendments to the Florida rules of qualified and court-appointed parental coordinators, and they updated the parental coordinator rules in accordance with the statute. 37, Prinova v. Doyle and Prinova. Trial court was reversed for enjoining funds in a paternity matter without setting a bond or any kind of explanation as to why the injunction should have been entered. So that was reversed. Next up is King v. King.
King v. King, which is a fourth district case. This involves a dissolution of marriage matter. And here, the trial court signed a proposed order verbatim with all of the spelling and grammar errors in it, as well as the conflicting paragraphs and conflicting findings of fact throughout the order. And here, the fourth district said this is a perfect example of where the court did not exercise its independent decision-making authority by signing such a proposed order that I've just described. And they talked about this being a Berg-Perlow issue, but most importantly, had there been a transcript, so spoiler alert, there was no transcript in this case either, but had there been a transcript, one of the ways that you can rebut this exercising independent decision-making authority issue that Berg-Perlow talks about is if the appellate court can see in the transcript that the court actively participated in the proceedings and was, part of it and asking questions and making, active rulings and things along the way, oftentimes the higher court, the appellate court will uphold, can overturn or uphold this issue based upon the fact that they see that the trial court actually participated. But without a transcript, the fourth district here was stuck in a difficult situation, and looking at the face of the judgment on itself, there was all sorts of problems. So this case was reversed and remanded for the court to clean up and correct its problematic order. And also the fact that the court needed to exercise some independent decision-making authority, and it was not reflected by the record here. So interesting case out of the fourth.
And our next case is Edie versus Gillis, and it dealt with relief beyond the scope that was requested, and the appellee was arguing that makeup time was awarded when it was never requested, actually the appellant, but the other party had requested compensatory time sharing, and the matter was tried by consent. So Edie v. Gillis, be careful about objecting to things beyond the scope of what is requested. 40, Weishart v. Weishart. Does a court need a reservation to enforce an order? The answer to that is no. In dissolution cases, like other types of cases, it is axiomatic that a trial court always has the inherent jurisdiction to enforce its previously entered orders. This continuing jurisdiction exists regardless of whether the court actually reserves jurisdiction to enforce such orders. The continuing jurisdiction extends to enforcing marital settlement agreements incorporated into dissolution judgments. So the only point they make is if you're trying to enforce something, you got to come back to family court and do it in the case in which your divorce was opened. So a good procedure case in Wise Heart if you need it. And that takes us to Vala Russell.
All right, so Val Carcel is a fourth district case, and this was a motion to vacate issue under the new 12490 rule. And in this case, the trial court just simply denied the motion to vacate the proposed order without a hearing. And the court is not permitted to do that under 12490. A motion to vacate must have a hearing. It is mandatory in order to protect the parties' due process rights. So you can't just in chambers deny a motion to vacate. So this was reversed, and the trial court judge was instructed to conduct a hearing on the motion to vacate.
And that takes us to 42, which is our last procedure case, Domin versus Domina. And this dealt with a temporary relief hearing that didn't finish, so they reset it and it didn't really finish. And the husband's attorney said, well, when do I get to put on my case? And the court said, well, I gave you more time than we usually have, but the court did not take into consideration the delays were caused by the other attorney, by it being a Zoom hearing, by other matters being argued that weren't anticipated. And if you don't give someone the right to put on their case, even at temporary relief, that would be grounds for disqualification of the judge, because it you cannot. We find that this allegation is sufficient to place a reasonably prudent person in fear of not receiving a fair hearing on their legal claims. And there's a fun quote in here that the court has recognized that justice cannot be administered arbitrarily with a stopwatch. Yet that is what happened in this instance. So you got to take off the stopwatch and give people their fair day in court. That is the last of the procedural cases. Now we're going back into injunctions, but these are protective injunctions, and really they're all the same. It's just we didn't want to have to move all of our materials around at this last moment, so we kept them the way they are, but we have 3 more injunction cases. The first one is 43 in re amendments to Florida Supreme Court approved family law forms 12980A FNQT. And that's the Grayson law factor into all the domestic violence injunctions, that the court must consider whether the respondent has engaged in a pattern of abusive or threatening purpose that demonstrates continuing purpose. So all of the Grayson's law factors are now in the forms. 44, Maloney v. Maloney. This was an interesting case where someone was making false claims of abuse against a military officer, and the court granted a stalking injunction, but there's other reasons why you might be making claims of abuse against the military officer. There was no imminent danger of being a victim of domestic violence. It was just trying to silence the squeaky wheel. The injunction had expired, but the appeal was not moot because of all the collateral consequences of an injunction. And appellate courts routinely consider appeals from expired domestic violence injunctions due to the collateral consequences that can flow therefrom. That was the Maloney case.
The last injunction case, I promise it is the last now this time, is a Jane Doe case, Jane Doe versus Days. This is a first district case that involved a stalking injunction. And here the petitioner, Jane Doe, filed a petition for protection against stalking. and the court just simply denied her petition without conducting a hearing. And pursuant to 784.0485, you must have a hearing on a petition for protection against stalking. So this was reversed and remanded for the court to conduct an evidentiary hearing on this petition from Ms. Doe. And then we're going to hop over to relocation for a second. We have a couple relocation cases between June and August. This is number 46 in your material. It's Ayala versus Vega. It's a 4th district case out of Broward County. And in this case, the father asked to relocate out of the county. I think he was moving to Brevard or Palm Coast area, something up the coast from Broward County, so up a bit. And his relocation was granted, and the appellate court affirmed the relocation. And in the trial court's order granting the relocation, the court gave the mother the majority time sharing with the child, because the mom was remaining in Broward County and dad was moving. And dad appealed, complaining that the mom had not pled for a modification of time sharing, which is an interesting and kind of adorable argument that he made when he was seeking a relocation. And the appellate court kind of slapped him on the hand and disagreed with him and said, look, mom answered your relocation petition and mom pled for majority time sharing in her answer. More importantly, each of the parties put on evidence and proposed parenting plans during the course of their trial, asking each one of them respectively asking for their own majority time sharing. So the appellate court said, not too fast. This issue was clearly tried by consent because mom put on her majority time sharing parenting plan. And in fact, dad did his own too. And dad never objected to mom's presentation of majority time sharing parenting plan. So the court was well within its rights. And, conceivably, if one parent is relocating, it is very likely that someone is going to get majority time sharing. So it was not an improper modification, and the judgment was affirmed. And Eddie has one more relocation case, which has
The pun
great
matter.
name. Great
There's
name.
no pun here. The relocating parent objected to a final judgment denying the relocation because they thought the judge had a presumption against relocation. The appellate court looked at the record, didn't find any hint or scintilla of any kind of bias or presumption, so the denying was affirmed. Continuing with the it's hard to relocate line of cases. Support, we have a really fun good fortune case, and good fortune cases usually are deviations down from presumptive amounts because a party makes so much. But in the TTL FAL case, the good fortune parent did not participate. He avoided discovery, his pleadings were stricken, and he did not even participate in the final hearing. Needless to say, the court disregarded the guidelines and gave a very small child support award based on what the child actually needed. So mom appealed this and said, you can't reward dad for not participating in this case, not being candid with his finances. In fact, I had to subpoena his bank, and the judge went through his bank accounts and based on his bank accounts could only tell if he was making $67,000 per month net. So the deviation from the guidelines was reversed. And because there was, in this case, no real good argument to reduce the child's support except to award someone who didn't participate in the proceedings. So do you know who FAL is, Karen?
I do not, but you shared with me earlier who it was. So
I have
spoiler.
I have no idea who this guy is, but I thought he was going to be an athlete, but this is no athlete. This is
He's got so much love. Look at all that love.
just call me Dabadi. When I first, because this is a paternity case, I thought that said just call me daddy, but it's Dabadi. So that's Mr. Love, ironically, who did not participate in his son's life and has posted in here that he is evidence. The irony just,
Wow.
I can't get over the irony
This
of it all.
is great. This is great. So do we know what he does?
He's a
No.
comedian
Oh, he's
and
a
entertainer. You can look him up on YouTube, and I can't imagine he's making 70 grand a month from that, but he's making 70. Apparently, I don't know.
We're doing something wrong. I don't know.
But I'd never heard of Mr. Love until I went diving, docket diving.
He's
and,
the body.
the body.
The body.
So you learn something new every day. And I guess what we really learned out of this was participate in the freaking paternity action, Mr. Love.
Oh, it's not that we're old and not cool and didn't know who he was, right?
Well, that's
That
just
too.
like a given. But Mr. Love doesn't have much love for our judicial system. Get it?
Oh, dad joke. You were
And
good.
Love isn't even his real name. It's Langston Fazon Santissima. Langston, why don't you get involved with your kid's life and you won't have to pay so much support? I don't know. All right, enough of Faison Love. But again, we learn something new every day. And what would the show be if you didn't walk away with the identity of the initialed Good Fortune case?
That's what you can talk about at cocktail parties. It's not the law. Come on. It's just who Mr. Love is.
Yeah, but no one's going to know.
Oh, come on. I'm assuming if he's making 70 grand a month, there are some circles who know who he is.
If you know Mr. Love, email me. I want to know.
Yes, or if you've been to one of his shows, we definitely want to know.
We did reach out to Mr. Love's attorney, but he did not want to participate in this interview. So I always try to get some interesting content for the show. Next case. Are we done with Love? We're done with Love. 49. Another initialed case, but not nearly as interesting as Fazian. MD v. TT, and the court erred in a case finding that there were no, I have Mr. Love's docket right here, the whole docket. Going back to this other initialed couple, the mother alleged that the father persuaded her to sign a stipulated settlement agreement in which she agreed to waive child support by providing false information about dad's employment and income. So the magistrate did not vacate that order, even though it left the child with no support. That was problematic because it left the child with no support. In the report, the magistrate stated that while the mother reported feeling manipulated and pressured into executing the stipulation, he was hesitant to accept the accuracy of her explanation because she filed her motion after the father refused to allow her to relocate outside of the state. So there's all these weird appearances of impropriety, who's doing what. But the law says she was entitled to an IWO, and the child, you cannot waive support. So, sorry, Mr. TT. And we did not dox you. Harvey versus Hill. It's a really short opinion, and the appellate court reversed with the trial court to attach child support guidelines that contained income information that didn't conflict with the final judgment. So in Harvey, the attachment conflicted, automatically reversed. Harvey v. Hill, ladies and gentlemen. 3 more cases to go.
If they're forgetting to attach the guidelines, now they're attaching wrong guidelines. No transcripts.
That was Mr. Love's guidelines. No, he didn't participate. I'm sorry.
There was no guidelines. He didn't have any.
Guidelines. We don't need no stinking guidelines.
Oh, heavens. All right. So we're
Parker v.
almost near
Parker.
the, thank you for sticking with us. So we're at 51, Parker versus Parker. And in this situation, this is a 6th district case. The 6th district noted that most of the trial and most of the transcript focused on the wife's requested relocation and then the husband's requested time sharing with the child. And in fact, the court noted that there was very little financial evidence presented. However, the court awarded child support because, you know, it has to. So the court awarded child support and child support arrearages against dad, but mom had never actually pled in her pleadings for child support arrearages. And I'm using air quotes around that because what the 6th district launched into a discussion about how it really wasn't arrearages, it was really retroactive support. But because the trial court, because the parties called it arrearages, the trial court wrote it as arrearages, but it's really retroactive support. And what the court noted is that even if a party doesn't plead for retroactive support for the minor child or children, the court has inherent authority under 6130 subsection 17.
And we had a whole lecture on inherent authority.
Yes, there you go. So the court has discretion to award, quote, retroactive support, which is why there was this long discussion in this opinion about that it wasn't arrearages, it was really retroactive. And because it was retroactive, the court had the authority to award retroactive support not to exceed 24 months or the date of the party's separation, whichever is shorter. So there's that. And so this entire case ended up being affirmed in part, reversed in part, but the arrearage / really retro number was totally fine, and you don't actually have to plead for it because the court has it, but good practice to probably plead for it just to make sure you're all right. But it is in 6130 subsection 17. Finally, hopping over to temporary relief for a second. This is the Miller versus Gordon case out of the 1st District up in the Panhandle. This involved a paternity case, an initial paternity action, and there was a temporary hearing about temporary parenting, and an order was entered. And, to put it simply, Dad didn't like the temporary order and he appealed it. But the 1st District noted the court has very great discretion in determining temporary parenting plans. And Dad didn't get equal time sharing. He got much less than equal time sharing. And he was upset about that. And there was a whole discussion about the fact there was a paternity case and he hadn't really been involved, kind of like Mr. Love. But nonetheless, he was upset that he didn't get his 50-50. And it should be noted that this Miller versus Gordon case was all decided at the trial court level before the law changed with this equal time sharing presumption this summer. So we might have a different situation now. Miller versus Gordon is kind of stale, but really what it stood for is that the court has this great discretion when fashioning temporary awards of money, time sharing, you name it. So appealing temporary orders is always a real gamble and a costly thing. So
speaking of appealing temporary orders, case 53 Williams v. Williams was an appeal of a temporary order. And the 1st DCA said, you don't have trial court. Don't you worry about all these 6108 alimony factors when you're deciding temporary alimony, because we're not going to require that. Those were only for final orders. But you can't be granting interim equitable distribution unless it's pled. So that part was reversed. And hence, the 1st DCA made everything right in the Williams v. Williams case. Well, Karen, that wraps up not just this quarter, but season 3 of our awesome CLE.
53 cases, how many episodes, and all of these wonderful hours with you folks.
I think in 3 years, we've done 28 episodes plus specials. We've done the mental health specials, the board cert specials, and a lot of fun. But this year we did it quarterly. The 2 years before it, we did it monthly. It's a lot. So Karen and I are going to take a much needed break. And instead of rolling out another season of CLEs, we're probably just going to do one-offs in the future. We love raising money for the Center for Child Counseling. And we raised a lot of money in 3 years, but it's time for us to take rest. So keep your eyes open for our 2024 edition. It will be a one-off CLE. And we sure do appreciate you taking the ride with us and supporting a really worthy cause in the Center for Child Counseling. And I want to thank my partner, Karen, for putting up with all this and coming along for the ride and creating some really good content and making some fun memories. Karen, it was a blast.
Thank you. And wishing all of you a very happy 2024. We'll see you soon.
And if you don't have your Funko,
it's a great Christmas and holiday present.
Author, would you please read us out for this last episode? Everybody, have a great year.
Thank you for joining us for this month's edition of Stephen Squibb's Monthly Family Law CLE. We hope to see you again next month. In the meantime, do something that matters. Visit www.eddiestevens.com for more information.